Hi, I'm Patty Rodson. I'm the chair of the Professional Development Committee and the Education Working Group and the Professional Involvement Group of the Champaign County Association of Realtors. Welcome you to a short sale panel discussion featuring 3 area attorneys who have extensive experience in the area of short sales, and we'll share their opinions. We will also be doing questions and answers at the end of their discussion. Our guest speakers include Jason Barickman of Meyer Cable. He's in Champaign. Jason's practice focuses on real estate, including acquisitions, sales, and developments of the office buildings, multifamily residential properties, industrial sites, and other residential and commercial properties. We have Christina Gilbert Manuel of Manuel Law Firms in Mahomet. Tina is the sole proprietor, concentrating in real estate transactions and real estate planning. We have Stephen K. Sheffler of the law offices of Stephen K. Sheffler of Champaign. Stephen's practice is primarily in real estate, landlord-tenant issues on behalf of the landlords, businesses and creditor representation in bankruptcy matters, collections, corporation, and business matters, wills, trusts, and probate. And we're going to start our panel off with Mr. Barickman.
Okay, so is this on, Matt?
That's for the recording, it's
All right.
not for amplification.
Got it. Does it help if we stand maybe too? All right, good afternoon, everyone. Thanks for having us. Hopefully today's outcome is a good one where we can convey to you some answers to the many. Oh, disclaim away.
Yeah. I'm sorry, I forgot the disclaimer. This session is being videotaped. Opinions expressed in this presentation are solely those of the presenters and do not necessarily represent the opinions of the Champaign County Association of Realtors. The presentations are not an endorsement of products or services by the association.
I suddenly feel like we should circulate a sign-in sheet where you agree with that for us. Okay, well, the 3 of us were talking about maybe how we approach answering the questions that you might have. I don't think any of us have prepared anything formal to talk about. We each thought we'd kick off by giving you just a brief synopsis of some of our experiences with short sales, and then leave ample time for all of you to ask whatever questions you may have. I've spoken on short sales to a number of you over the last several years, and I won't even ask in this room, but when I first did them, I think it was back in 2005 or 6 was my first short sale. And shortly after, I did a presentation to a group of realtors, and I asked at the time for a show of hands from everyone who at that time had been involved in a short sale. And there were, in a room of 30 or so realtors, maybe there was 3 or 4 hands that went up. Today, if you ask that question, every hand in the room goes up. Whether you have been involved in as a listing agent with a seller who's been underwater, or you've been on the as a buyer's agent dealing with the many issues that come up from the buyer's perspective when you're trying to purchase a property. It seems today that almost every realtor I talk to has been at least in one of those. Most of them tell me that they've become very frustrated with them, and most tell me they wish they didn't have to deal with them. Like the good old days when we didn't have short sales. The reality is, in today's market, we've got a lot of these going on. From my perspective, when I get a lot of calls, primarily from you, as kind of my first point of contact on a file. There is an entire, you might say, short sale world that is happening in the commercial market, and that is very different than the topic that I think I'll touch on today. For those of you that deal with commercial real estate, short sales are being performed. Investors are buying those properties, and I certainly would be glad to talk with you maybe offline about how those are different than the residential world. But I'm presuming that most of you in here want to talk about what's happening in the residential world. And that for me is a process that, as I say, primarily begins with a call from a realtor who tells me, I'm in a transaction and there is some distress in some nature going on. Here's the way I try to analyze those. First thing I want to find out is who the realtor is representing, the seller or the buyer, who I'm asked to represent, which becomes a very critical component for us as attorneys, because our representation is a fiduciary one, just like yours is, to someone, and that begins immediately. So when you call us and say, yeah, I've got a seller, and that seller owes a bunch of money to Bank of America, and there's no way I can list this property for that amount of money to pay them off, where do we go? I'm immediately thinking about, well, what they're really asking me is for some guidance on this seller who will likely become my client in this. And so that's my frame of mind. Sometimes we have buyers who are out there struggling in a short sale where they're not getting information from a seller, where they're wondering what their contractual rights are because they agreed to a closing date of September 26th, and that date has long since flown, and they're not getting any information about what's going to happen to enable this closing to happen. So again, part of my analysis begins in who am I representing and what's their goal here. If the goal is to represent a seller who's distressed, then my next questions are, well, what's the distress that they're going through? Most of these are people who've lost income, have a divorce, maybe had some medical injuries that's resulting in this hardship. The other question I like to know is who's the banks that we're dealing with? It's a very different perspective for me if we're dealing with Busey Bank versus Bank of America. Busey Bank, I can call up Dave Strang or someone over at the bank and figure out within a handful of days what we need to do to get a short sale approved, whereas if we're going through a Bank of America or Wells Fargo, PNC, we're going to go through an extremely rigorous process that is going to take a lot of time to complete it. If the result of that conversation is one where I see an opportunity for a sale to be conducted, then we'll talk about how to move forward. There are times when you'll call me and I'll tell you my advice is to get out of the way, because I'm certainly not interested in representing that individual. I can't provide legal advice to someone that I don't represent. And I think on this one, there's times where I'll just tell people, I'm going to take a pass. You may want to take a pass because it sounds like you're spending a lot of money marketing a property that doesn't have an opportunity for a sale. To give you an example of some of those, a lot of times we have second mortgages, second lien holders, mechanics liens, with individuals who are unwilling to negotiate. Realtor calls me up and says, here's the deal, my seller's underwater, they owe Bank of America a bunch of money, can you help? I said, sounds like it. They said, well, by the way, there's also a $20,000 mechanics lien with the contractor down the road, and that contractor said there is no way he's going to take less than $20,000 to release his lien. That to me sounds immediately like a very difficult obstacle. Not impossible to overcome, but very difficult. If you've got lien holders who are unwilling to negotiate, it's going to make it extremely difficult for us to negotiate those liens down. So that's kind of my front end analysis. The other question I asked the realtor is, who's going to actually negotiate on the seller's behalf? In some transactions, the seller wants to do that themselves and maybe has already initiated that. They've sent correspondence to their bank sent correspondence back to them telling them this is what we require of you to complete a short sale. Sometimes the realtor wants to take that. I know some of you have decided that that fits well with your practice to take that role. Once in a while, the buyer will want to facilitate that and handle that role. And myself, I've used third parties to handle what I call the administration of the short sale. I think there are benefits and cons to any of those individuals handling that piece of the sale. The seller and the buyer, to me, caused me the most heartache as to them being involved in the administration of the sale. Sellers who are in a distressed situation tend not to be great record keepers. They tend to not be very timely in their correspondence. They tend not to write things down. And when you're dealing with banks who send emails and say, we need a response in 24 hours or 48 hours, or they say, we need this and you send us something else, when I have sellers who are responsible for that piece and I find out they sat on something for days or a week and it blew the whole transaction up, it makes me very suspicious as to whether or not that's useful for any of us, for not just wasting our time dealing with someone who's not capable in handling that piece. Buyers tend, in my perspective, buyers tend to be very motivated and, for the most part, reliable in that negotiating piece with the bank. The difficulty there is you have a complicated scenario where you're asking a seller to turn over a bunch of financial records to a buyer, and basically you're leaving it on the buyer's plate, who has no responsibility to anyone to follow through or to be to conduct themselves in an honest and ethical way. So that sometimes causes concern. Realtors, I've had a tremendous amount of success with these. Some of you are very on top of your game. You're very organized. You say, this fits well, I'm going to tackle it. Jason, once I get an approval letter, I just need you to close it out. That's a great scenario for attorneys. We kind of sit back and wait for you to do your part. Others of you say, that doesn't fit my practice well. I want to be out selling real estate, obtaining listings, showing homes, and I don't want to be sitting behind a desk managing all these emails and faxes of 50-page documents and otherwise. So I mentioned I use third parties occasionally for my short sales. Some of you know I use a company called Short Sale Pros, which is a company I have a financial interest in. That company charges buyers fees for completing a short sale. They sign a contract with their seller, which creates the obligation for them to perform and do certain things. And what I found is that buyers are willing to pay a fee. They basically, from a buyer's perspective, they include that fee in the cost that they're willing to pay for the purchase of a property. If they know that there's a professional who is administering it, they feel confident in that and rely on them to complete the process. The process, I'm sure we'll talk about this endlessly, but the process is unbelievably unpredictable. I've had Bank of America short sales that have been completed in 2 weeks. I've had Bank of America sales that have taken over a year. Many of the complications that I often see are whether or not we're dealing with two lien holders and who the investor of the loan is. What I mean by that is when you borrow money, you sign a promissory note. I promise to pay you back $150,000 that you loaned me at closing. And those promissory notes are basically being sold on a secondary market to investors. We read about it. It's national news these days of how these have been packaged and sold. But the investor behind that loan is the one who's really driving the process you have to go through, the due diligence, we provide financial documents and otherwise, and they're setting the criteria for what needs to occur and how much money needs to show up before they're willing to approve that sale. And so you go through these whole front-end processes with a servicing agent, the lender that we think of in our minds, and at the end of an entire negotiation, you hear from the servicing agent, okay, we've made it through all of my hoops, now I need to turn the file over to the investor, who generally makes very quick decisions, but not always does. That investor will tell us whether or not the sale is approved or under what terms. So I have found that these are tremendously interesting files, actually. I've sometimes told people that doing residential purchase and sale work is good for attorneys. We enjoy it. You can complain about it because sometimes it's routine, I suppose. Short sales are never routine. There's a million questions that come up, and they actually make the day very exciting sometimes, very frustrating many times, but I've enjoyed doing them and enjoyed working with many of you on them. So with that, I'll turn it over to Tina.
Is this close enough to the microphone, Matt?
Yeah.
Okay. Unlike Jason, I have not been doing this as long. I really enjoy the real estate industry, and I basically concentrate in real estate transactions and estate planning. And I had somebody ask me about a short sale one day, and I said, you know what? I know that they're out there, but I've never really been involved in one. And so I did a little bit of research, and I thought, well, hey, that sounds fun. And when that's usually the reaction that I get. And so I actually call it my hobby within my practice, and it's a little bit of brain candy, because as Jason was saying, real estate transaction get a little bit routine, and this spices it up a little bit, sometimes for the better, sometimes for the worse, but you're never going to have any two that are the same. I also, unlike Jason, I'm a control freak, and so I like to basically do as much of it myself as I can. And that way I don't have to worry about anybody blowing a deadline except myself, and then I don't have anybody yell at but myself. So I take a very hands-on approach to it. One thing he didn't touch on was Equator. I know I got into this just at the very beginning of the usage of Equator, and at first it was horribly disorganized, and so you were faxing things to Bank of America and PNC and Wells Fargo, and then they wanted you to upload them into the system as well, and everybody's saying, where is it, why don't I have it? And I'm saying, I faxed it and I uploaded it and nobody can find it. But now I find that it has really streamlined things, and it helps my clients, whether they be the sellers or the buyers, to know that the documents are actually going to the person that's supposed to see them. Whether or not the person looks at them when they get them is a completely different story, but at least I know that they have them. As Jason said, what bank you use is really going to make a difference, and the second lien holders are always a pain, especially if you're dealing with a Freddie Mac or a Fannie Mae loan, because they have guidelines, and so they will only give people certain percentages, and it's a very low percentage, usually around 6%. And if you're owed $20,000, who's going to settle for 6%? And that's when we all get to chip in money. We have the sellers chip in money. We sometimes ask the realtors to chip in money just so that we can see it close. And he really touched on everything else, so that's really all I have to say. So I'll let Steve say a little bit, and then we'll take your questions.
Thank you, Tina. One of the items that has not been dealt with yet, and which comes up for an attorney, is oftentimes these transactions will involve a property that's in foreclosure. And then you'll get the inquiry, well, are you going to do the short sale? You're going to get into the foreclosure case? You're going to do this, do that? Well, that, in my experience, creates problems, because if you're going to enter your appearance in the foreclosure case, you're going to be spending a lot of time probably monitoring the foreclosure, going to court. There's going to be usually an appearance fee, at least for the defendant. You're now talking about an additional set of fees, and you all know that when these people come to you, they're not looking to pay anything. They have a problem and they want it fixed, and they don't have either the resources or the commitment to put out the funds that are necessary up front. So that creates a problem. And then the second problem with the foreclosures is that you try to explain to the owner slash seller slash person in foreclosure that these two things are on a totally different track. And occasionally there will be communications between the lender or the negotiator and the firm that's handling the foreclosure, but frequently there is little or no contact there. So the attorneys that are hired, and most often they are not of this area, they are usually Chicago area firms. There are 3 or 4 firms in the state that handle most of the first mortgage foreclosures. Oftentimes you can't even get to talk to a person who's handling that file, even if you are involved in the case, in the foreclosure case, because they will send a local attorney to appear whenever things need to be done here. Now, that's not always the case. There's some firms that don't do that, but going in, that's the potential, is that you're not going to get a whole lot of attention from the attorneys handling the foreclosure, and even if you do, their directive is to proceed until their client tells them to back off. Sometimes these things go right up to the foreclosure sale. It's even been published. We're nearing the courthouse steps for the sale. Somehow the whole process has slowed down on the other side, or it's not moving nearly as fast as on the foreclosure side. And now we've got a problem in that somebody out here, a seller, a buyer, maybe a buyer's lender, certainly the realtors, everybody involved in the short sale transaction are expecting it to move forward, and it's not moving fast enough to keep pace with the foreclosure case. That's a real problem. How does that get resolved? Essentially, oftentimes the people on the short sale side will come to their senses, and I don't mean the attorneys or the realtors, I mean the people in the negotiating and in the financial side of it, and will give the word to the side that's pursuing the foreclosure to back off, continue the sale date, hold off on going through the foreclosure. There are things like that that occur, but there's no guarantee that that happens. So that's a problem, and I don't know how to predict going in how that will happen. You may even start with a short sale, and like Tina saying, or Jason, one of them was commenting about how long these procedures take, and sometimes you may start with something that wasn't in foreclosure and then, well, gee, I just got served a summons. Yeah, you haven't made a payment in 6 or 8 months. They're going to go forward with a foreclosure. Well, I've got a short sale pending. Well, their attitude is, so what? Not they, the seller, owner, but the lender or investor's attitude is, so what? And you have to deal with that issue when it comes up, both as an attorney and as a realtor involved in a transaction. As far as my experience in short sales, I go back 5 or 6 years in doing them. Some of the first ones I had, a number of them where people were asked to sign a side note for a lesser amount than the shortfall on more favorable terms, but that was something that was being required. I haven't seen as many of those recently, but that's still the potential out there based upon the credit rating, the financial circumstances, the hardships, any of which is anybody's guess how that's going to fall when you start a transaction. So that's another thing that you encounter. From my perspective, I've never dealt with really a third-party entity that intervenes in between. I don't have any financial interest in any companies that are involved in that. I perceive my only client is whoever the seller ends up being, if that's how I get involved in a transaction, or if I'm brought in on the buyer side, it's the buyer. I think one of the things, if I'm on the buyer side, is I try to caution the buyers that no matter who's working this, you're not going to get, not likely to get, a quick and satisfactory closing because it's a short sale, and per se a short sale, you need to be ready as a buyer to go the long haul. I think that's one of the primary problems in the whole short sale process, is that oftentimes buyers just don't have a clue how many times this thing may take different turns and how many delays there may be, how many times they may be expected to sign extensions. Oftentimes sellers don't understand how many times they may have to resubmit and reprove their qualifications with their most recent earnings, whatever, while the whole procedure's taking months to come to that point. And I would say that one of the most critical parts of it from both the attorney and particularly the realtor side, because the realtor's dealing directly with the buyer and the seller, whoever it is that is your client in the transaction, is to try to warn them in advance this is anything but neat or quick. Be ready for twists and turns, be ready for delays. My own experience is you can go through this process, you have it all ready to go, and then if there's a buyer that, heaven forbid, is a first-time buyer trying to buy a short sale property, but anybody who's trying to get some sort of financing who doesn't have it set up what I will call more or less an investment or commercial loan arrangement and is trying to get a traditional loan or a first-time loan, is going to have their lender moving them towards getting a loan and not knowing when that's going to come to pass because of waiting on the seller's side. And I don't know, maybe Jason can explain, but I don't know how you deal when you're dealing with a third-party entity here. How do you get the sellers to continue to supply the information? Because I think the sellers are critical, and sometimes they don't get motivated. If they've moved out, they can walk away from it. I mean, somebody's got to supply the information no matter who ends up submitting it ultimately to the lenders, and that's a real problem that I see as well. So, and the other thing is, we're probably not going to get paid anything, either the lawyers or the realtors, unless this deal closes. We have more motivation sometimes than the people out there who are the short sale sellers, okay? They want it to go away. They can't understand why it's taking so long. It's like, hello, there's a problem here. That's why we're in this situation. And if you want, for the long haul, to come away with this with any kind of, shall we say, not unblemished, but less blemished financial or credit rating, you want to play the game and see that it takes its way to the conclusion. Now, trying to keep somebody on track with that is hard. I mean, I've gone to closings where the sellers, who I think should be happy that it's closed, are bitter. And they don't like what the realtors did, they don't like what the lenders did, they don't like what the lawyers did. And it's like, well, I guess that's one of the things that you need to be prepared for going in, is that that will happen. So I'm going to have a seat here, and we'll try to turn over questions. Thank you. Yes?
Steve, you were speaking of how the sellers sort of give up. What happens when they tell you that, oh, well, we signed a deed in lieu, so we can just leave and it's done? What would be a good response?
Well, the first question is did they sign a deed in lieu? Have they actually done that?
Well, that's what, you're told. Are we supposed to see it and look at it and review it?
Well, a lot of times they don't know what they've done. And they think they signed a bunch of papers and that they can walk away from it. And I know that some of the programs, ultimately, if the short sale, if there's no buyers on the horizon for the short sale, they'll do the deed in lieu. But I really haven't encountered where somebody comes and says, I've got a deed in lieu. What I will more likely have is somebody that runs away and hides and you can't reach them, or when you do reach them, are complaining about the whole delay ordeal and why is this taking so long. If somebody says they've got a deed in lieu, then I think that you should ask for them to produce it. I mean, who have you been talking to? Have you been talking to the attorneys? Because usually the deed in lieu comes from the attorneys handling the foreclosure. And it's not probably going to come from a negotiator's office. I mean, I have yet to see one that way. I can, tomorrow I may see one, okay? But I haven't seen one yet. And so you need to try to find out who they're dealing with if they tell you that kind of thing is going on.
I'll have maybe one point, which is what I try to do on the front of these transactions is order a title search and figure out what exactly is going on, who owns the property, what encumbrances are on it, and that might be a good first step there. Now the question is going to be who's going to pay for this search, but there are many times questions about who actually owns the property. Sometimes you've had conveyances, a quitclaim deed being signed between one ex-spouse and the other. Sometimes you may have a situation where they think they've signed a deed to the bank, a deed in lieu. A title search can clear up, who the rightful owner of the property is. If the bank owns it, there's probably not much more for you to do as the realtor unless the bank hires you to list the property for sale.
So Jason, what do you do when you've got these third-party entities involved about the sellers cooperating and supplying documentation? Because I know you said that helps to move things along, but how do you ensure the owner's compliance with whatever the third party's doing?
Yeah, there's certainly no guarantees, but I explained that my role oftentimes is the educator. And I always talk to my seller clients up front. I mean, that's the next, after a realtor's conversation with me, my next conversation's with a seller. And I guess I would say I'm extremely firm with them about what is required of them to ensure this will be completed. And if my sense from them is that they are someone who's not going to cooperate, then I tell them that I'm just unwilling to work with them. Maybe someone else will. But you certainly, for me, what I've learned is if you set that tone up front, that here's what we're going to expect from you. And I'm just very clear that day one, you're going to need to produce 2 or 3 months of bank statements, of income pay stubs. You're going to need to produce 2 years of tax returns. I try to think about where we are in the tax return cycle. Come January 1, banks are going to start asking us for 2012 tax returns. And people are going to tell us, they're going to say, well, Jason, I haven't done my 2012 returns. And I'll say, well, you're going to have to sign a piece of paper saying you've not yet filed them. And my thought process is educate that seller day one so that they understand what their expectations are. Give them a checklist that's very specific. Every bank these days has different things that they want. So my checklists are tailored to the bank. And hammer on them that they are whether they believe it or not, they have the most to gain or lose from this being successful. I mean, I think we understand that. They don't necessarily understand it. But there are instances where I will tell people I'm not willing to work with them because my sense from them is they're not someone who's going to follow through. After that, when I mention the third party, I do not view my role as being one of chasing these people around, but the third party that I work with does. I've trained the person who does this to use a calendaring system where they follow up regularly and require that seller to produce what it is that they need to produce. And it's not perfect, but it does seem to work more times than not, I guess I'd say.
I'll just generally throw this question out there. I'm a newbie in the short sale, and we have currently, the contract I had written in 2 weeks. Everything is, will close within 30 days of approval, but right now the contract has expired. We were told that, and this is a Wells Fargo, we were told that it had been moved on to the short sale department, which sounded positive. So what do you think's going on there now? It's just sitting on somebody's desk. The fact that the date has come and gone, is that of no importance? Will they still continue to work it? Or are we supposed to resubmit? Anybody?
Do you mean resubmit the entire contract?
Right.
You just need to do an extension. They'll continue working it if someone's bothering them.
And also, we were told that they did an appraisal, they meaning Wells Fargo, they did an appraisal, and the property came in at 112, and we're 10 off of that, 10,000 off of that. So they counter specifically at the appraisal. Well, how many people are getting their appraised prices? I mean, seriously, are they looking to get the appraised price?
It depends. I mean, it depends on who you're dealing with and
And it's been on over a year.
well, then the longer it's been on the market, the less likely I think it is that they'll necessarily stand by the absolute of the appraisal. But hey, try to figure out what's going through their minds and how they're going to deal with it is the big question. And I never know. I never have a clue.
I just didn't know because the expiration date had come and gone, if that was even important to them and I should keep resubmitting extensions.
I would really like to see a contract where the closing date hasn't come and gone in a short sale.
Well, it's not the closing date, it's the
The extra.
response.
Oh, for their,
Is that important?
no.
Okay, that's all.
The other thing is, if they are not moving, and you know, for instance, that they are stuck on 112 and it's $10,000 off what you can get, whatever your example was there, try to lean on them as much as possible to say, hey, look, this has been out there for a year. This is the only viable offer we've got at that level. There's no way they're going to pay more. Do you want us to walk away from this? Is that going to fall on deaf ears? Maybe. Your negotiator may be here today and gone tomorrow. Maybe somebody else. And it may get set over to somebody else. So, in fact, it can't hurt to lean on them.
I had luck in sending comparables to them too.
Sure.
You just got to stay on it. Jason, I have a question for you. When you charge a fee for the third party, and what would you be doing differently than what these two would be doing with your third party?
The third party is I call them an administrative assistant, a processing assistant. They are tasked with collecting the many documents and preparing what is an initial short sale packet that's sent to the bank. That's the 30 to 80 pages of financials, listing agreement, comparable sale numbers, everything custom tailored to the bank or banks that have a lien on the property. That in itself is a time-consuming process to gather those documents, to put them together and get them to the bank. The procedures that we put in place are that once however the documents have been sent, sometimes they're sent by email, sometimes they're sent by fax, sometimes they're uploaded into Equator or some other electronic system. However they're submitted, we like within 72 hours to get a verbal confirmation from someone on the other end that says, yes, I have received the 72 pages that you faxed or sent to me 3 days ago. Here's what's going to happen next. The bank tells you, I'm going to set up a file, I'm going to upload all the documents, I'm going to go through my checklists and make sure everything's there, and that's going to take me 30 days, and at the end of that 30 days, if everything's there, I'm going to order a BPO. If we get that information back, what we do is calendar to contact them in 2 weeks and find out where they're at with it. So again, this is all handled by a third-party person, not myself. I think I've learned the hard way that the process of calling in and getting someone live on the phone who's got your file in front of you and can actually give you substantive information about it is while it sounds very trivial, it's an extremely time-consuming process. Sometimes it involves phoning 8 or 10 different phone numbers, chasing down people to get a supervisor on the phone, and you spend an incredible amount of time basically chasing someone to look at your file and give you something. But anyway, we follow a process where documents are submitted, we verify that they've been received, we find out what the next step is and contact the bank before that next step expires. What you'll find out is they'll tell you to call back in 30 days. If you call back in 7 or 10, you'll find out that, oh, in fact, they did look at your file and they realized that something was missing or there wasn't a signature on a tax return or something was wrong, they didn't bother to tell anyone that. They're not going to tell you that for 30 days when you know, but they'll tell you when you're on the phone. So then you chase down your seller, you get the information, you send it forward.
Yeah, that's kind of what we do.
Yep.
But I just wanted, so do you charge your attorney fee and then the third party charges a fee? And do you have to disclose that to the bank or to, I'm sure you have to disclose it to your people that you're working with.
Yeah. Yes and no. You have to disclose it to the people that you're working with, absolutely. My arrangement with sellers is that their fee to me is contingent on the sale being approved and whatever the bank pays you. I've had sales where the bank has certainly provided seller fees of $0. I think you regularly will see fees being approved at $500 to maybe $1,000. Sometimes it's more. Some of you who I've worked with on files know that as an attorney, I mean, if you value our time and believe the fact that for a regular purchase and sale, we're going to charge roughly $400 or $500, and that's based on our expected time in that file. The notion that we're going to receive a fee of $500 to $1,000 probably in no way compensates the attorney for the real amount of time that they're going to have in that file, especially if you get into unique situations like buyers who want to rent the property or move in early or do all kinds of things. So, but anyway, that's a long-winded response to I just take what the bank gives you, which generally is not a lot of money for the attorney.
You don't have to let the bank know that you're making money. Like if you have the buyers you're negotiating with and the seller pays, the bank pays you a fee, do you have to disclose that you're getting paid by the buyer too?
To the bank, you're saying? No. I mean, I'm not, I guess to put it in perspective, I'm not, I am a part owner of an entity that hires someone to do certain tasks. If that entity, I mean, they have obligations of themselves. At the end of the day, if that entity shows a profit, then as a shareholder, I'll recoup that benefit. If it doesn't, I won't. You know.
One quick reminder, just as we know from our continuing ed, refrain from a discussion of fees to the extent that doing so could create an antitrust issue. And then the general question that I wanted to ask and get responses from all three of you, what are the top 2 or 3 things that you've seen, and I understand that everyone in this room is infallible, but all the really sloppy realtors who didn't show up, what are the top 2 or 3 things that you see that really could be done better, or that are the top items of concern that are trouble spots that the realtors have within their ability to do better when they're working with you on short sales?
I'll go first. The biggest problem that I'm encountering right now is electronic signatures. I know they're new. I know they're much easier. DocuSign is nice. Adobe's great. Short sale lenders won't accept them. Everything has to be an actual signature. It can be faxed to me. It can be emailed to me. It can be hand delivered to me, but it cannot be an electronic signature. And so once you have everybody sign an electronic signature, especially for a seller who is gone, it's going to waste a lot of time trying to get an actual signature and get it back to us.
Is that true with all the lenders you deal with, or just some?
All of them I've encountered so far.
And just to clarify, when you say electronic signatures, that in no way prohibits or precludes the realtor from sending a facsimile via email, having the client print it, affix a signature, and then send an electronic facsimile back via email.
Faxes, emails, those are fine. It just can't be the actual
stamp signature.
Correct. Yes. And I have so far done short sales with Bank of America, Wells Fargo, PNC, GMAC, and Busey. And all Freddie Mac and Fannie Mae's, whether it's a short sale or not a short sale, they don't take electronic signatures either. So that's a big thing that I've run into recently since electronic signatures have become more popular, is no electronic signatures.
Chase is another one that won't accept them.
I would say try to find out up front what the expectations of these people are, the sellers and the buyers, depending on which side of the transaction you're on, because it's in a short sale. The buyers also have to be on board. So if you've got a buyer, you've got to. I think that's probably the single most significant thing that I see that gets overlooked, is that if you've got a short sale listing, you realtors do a pretty good job of identifying the issues and going forward. It's when the buyer comes into the picture, and the buyer oftentimes is not well versed or prepared for what may happen, and may have deadlines that they haven't even disclosed to you because you haven't asked them, hey, I've got to get into this house by the 1st of September or whatever, and it's like, it's not going to happen that fast. So that's one of the things I think that gets overlooked. I mean, you who have done the short sales on the listing side, you know what things lurk out there and how to address them, I think. I mean, especially if you've done several of them. But the buyer side, I think, is fraught with all kinds of problems, because if you've got the listing and you parade buyers through because one contract after another falls through, you're going in the hole. You're spending way too much time, way too much effort, and even if you get your sale and your fee, your commission, you probably are losing. And through no fault of your own, is the buyer side part of it.
Yeah, I'll probably touch on both pieces of this. To take Tina's comment maybe to the next piece, I've actually been telling people that the contracts that come in, while they certainly need real signatures, the other piece is they need to be clean. I've had, they don't ultimately get rejected, but some of the smoothest transactions are those where the contract is legible. Sometimes we go through, you've seen some of these contracts, by the time we all get them signed by everyone and initialed by everyone, there's lines, they're faxed back and forth, and banks do not like to try to decipher what exactly that says. So I'll actually, when I see that on the front end, I'll tell the realtors to circulate a new clean contract so that we have something that's legible when it gets to the bank. The other component, I would say the piece that frustrates me the most is not the realtor who's unfamiliar with a short sale or what to do or how to do it. I absolutely never mind taking those calls and walking you through the many components. The thing that frustrates me is when I get an email from a realtor that says, Jason, see attached for a short sale. And there's a 4-page contract with a closing date in 30 days or 60 days, and I'm thinking, boy, we've already started with our wrong foot forward. It goes to the expectations of the parties, and it goes to having a legally binding agreement that's going to survive the at least 3 months that the agreement will be out there. More likely 4 months to 6 months. I mean, these things take forever. When a realtor calls me and says, I've got someone who's looks to be a short sale, we've got some foot traction in the home, or we need your guidance on how to reduce our list price, those are great phone calls to guide the realtor through. Ultimately, what I tell sellers and realtors is, don't sign that contract unless you let me take a look at it. We're obviously going to need to add a provision. I have an amendment that I provide to those contracts that says the seller's obligations to sell are contingent on some third-party approvals. But there's a lot of other things in our 4-page MLS contract that are pertinent to the short sale. When the closing date is, I mean, if a buyer wants to close in 60 days and says, but I might be willing to take it a little longer, does not give me a lot of comfort, because it sounds like they've got some expectation that this is going to happen in a time frame that more than likely is not going to. I've been telling people, set a closing 120 days out. If the buyer wants a right to terminate after that, we'll give it to them, but give us plenty of time to do this. The inspection provisions are absolutely crucial. I tell people that it's best if the buyer's willing to do the inspection up front before we even submit an offer to the bank. Let's get that over with and find out what the problem is. Some buyers don't want to do that. They don't want to pay for it, and I get it. Another approach that I'll take is just to set the buyer's expectation. You can do your inspection once we get this approved, but we're not going to have any money for your $500 repair credit that you want at the closing table. If the buyer's expectation is that they get to do an inspection, and if they find out the roof's shot and it's going to cost $10,000, that's fine, because I can actually deal with that with the bank at closing, but I cannot deal with those $500, the meaningless things that we all fight over in closings. So we've got to address that up front. The termite provision, the contract says the seller's going to pay for a termite. Probably half of my short sales pay for that. The lenders pay for it. So I just have the buyer agree to pay for that, so we don't have to deal with that $60 or $100 charge. And then the other thing is I have the buyer agree to accept the property in its as-is condition. That includes all the systems. Sometimes buyers aren't, everything's negotiated, but in the ideal world, the buyer's going to accept the condition of the home, the systems. They're going to accept any personal property that's being conveyed in its as-is condition. And if you think of what our contract says, it says something very different than that. Our personal property says that the washer and dryer gets to go and that it's going to be in normal working condition. Well, if your seller has vacated the home and hasn't lived there in 6 months but left the washer and dryer, I'd certainly prefer that they tell the buyer, and the buyer have an expectation that it's going to be in whatever condition it is, and we're not going to warrant that. So anyway, I try to adjust all those things up front and come to a written agreement that memorializes the agreement of the buyers and sellers in a fashion that I believe is reasonable, that we can get an approval in the next several months on it.
I guess that brings about the question which I've always had. We're using a 4-page contract. We work with it like we do any other sale in this industry. Yet we get back from the company saying, here's 50 pages that says you're buying it as is, you don't do this, you don't do that. Is there a better way? We do have the memorandum. Would that be a better way to go with this rather than presenting the contract and then saying like you, okay, termite inspection, you're going to pay for this. Home inspection, you're going to do this.
Well, it's almost like you're dealing with a reload company, right? I mean, you when they are involved on the other side of the transaction, you're going to accept their terms, right?
Right.
Okay, so they'll start out with the MLS, but when they get done with it, it's what they use. Okay, so I don't see a lot of difference really there's difference in the ultimate documents, but there's not a lot of difference on the buyer side in their ability to control that. So I don't know that it makes a lot of difference how you approach it when you bring a buyer to the table. You just have to try to again educate them. Look, you're going to find some things in here that's not like you're going to find in another deal, and then there's no way around it. We're going to end up with some of these things dictated to us.
See, my experience is they wouldn't accept a memorandum because it's not legal and binding. The bank wouldn't pay for it.
So I've got
Well, I think she's assuming, though, that you would bring a memorandum and then a contract would come back after the memorandum, and then you wouldn't have to adjust it. Am I understanding that correctly?
Yeah.
Okay.
But I have a different workflow question that I think relates to that. Do all three of you use proprietary addendums that include provisions like the whole deal being contingent upon the approval of the third party?
I have some
Okay.
that I use.
All three of you do have some sort of an addendum that goes on to it that explicitly makes the contract contingent upon third-party approval. I know Jason does.
I don't have an addendum. I direct my realtors to put subject to third-party approval and have everybody initial it on the first page of the contract.
Okay, so then from a workflow standpoint, if, the question I guess is it your preference that a seller who's a short sale seller be in touch with you prior to the thing going under contract? Because in most cases, at a minimum, there's going to be specific direction from the seller's attorney as to what needs to go on that contract. And in some cases, it's going to be an entire detailed addendum that, just like the relocation company contract writer, if that's, we have the ability to post that right in our MLS in a non-public location where other agents can see it. We can then alert other agents in a non-public remarks field. Be aware, there is a proprietary short sale addendum that must be a part of all offers. Because without that, my concern is that it sounds like you are sometimes getting standard 4-page, fully executed MLS contracts with no short sale contingencies that is fraught with problems, or else you're getting realtors who have pre-practiced law without a license before it lands on your desk, and then you have to undo the damage.
Or you get, in reality, somebody that will go forward with that standard MLS signed contract, knowing that they're looking at a seller who can't pay them any damages anyhow. They're judgment proof.
So what's your preferred workflow for that then?
My preferred workflow is to have contact prior to a contract being signed. And while I think the legal agreement that's ultimately signed is a better one if we have addressed the many issues that I've talked about, Steve's point is right. If there's a dispute, there's probably not going to be a lawsuit because you're suing someone who's probably going to land in foreclosure and or bankruptcy. But it does help with the expectation setting.
Right.
And those expectations are going to be the reason it falls apart, because someone's, Bank of America has standard addendums. And if you don't tell your buyers that you're buying it as is up front, and those Bank of America, you get a message from Bank of America that says, hey, we're moving forward, but you need to sign these couple pages of documents. And the buyer's attorney looks at them and says, you thought, this was 5A2? Guess what? It's not. And your buyer says, well, I'm out because I don't want to find out I got to replace the furnace. Well, you just wasted, probably 60 days before that happened. And the seller might be in foreclosure, that might be happening, and you've taken it off the market, and you've now lost your buyer, and you've got to start over. I mean, it's just endless problems because you could have, on something you could have addressed on the front end.
So the proprietary addendum, if that's something that goes into the MLS and that the other agents and their buyers have to have seen and signed before it ever gets to you, then that's, if I'm understanding correctly, that if nothing else will help ensure some expectation setting has happened.
I would think so, yes.
Yeah, I guess I would say, though, I used to be providing realtors an addendum that said, hey, if you're dealing with a short sale and it's my client, use this. And I've shied away from that because I'm realizing that the transaction is more unique and there's an opportunity to address some of the other provisions beyond the third-party approval. And that can be done through a very simple addendum. But for me, the way I approach it is, you've got a transaction in the works, buyer makes an offer, the realtor forwards me the offer on an email and says, Jason, let me know what you think so that we can counsel our seller client here on this offer. And I will try to very quickly at least get out bullet points of this is what I think needs to be included if this is the offer that we're going to go with. And that is usually presented to the seller. The seller says, I like what Jason said, take it back to the buyer. And we have the buyer, rather than dealing with written counteroffers back and forth, we just tell our buyer, here's the seller's attorney's comments, adjust your offer accordingly. And if it's very unique, we'll say, these are the seller's attorney's comments, and he said he'll write it up if you agree to these terms, And again, at the end of the day, we've got a written document that sets everyone's expectations very well to all the specifics we need to.
Do you guys talk to your clients about negotiating no deficiencies? Do you touch that up front? Because I've noticed that some of the sellers have to have no deficiencies because they have no funds available. So, does somebody want to touch on that?
I do. The fun thing about this year is and I'm sure the gentleman on either side of me will speak about it also, is and I always get the words.
Mortgage Debt Relief Act.
Mortgage Debt Relief Act. I always get debt and relief mixed up. Anyway, what it basically says is after you sell this, if we can't negotiate a no deficiency, then you can negotiate a note. But like Steve said, I haven't really seen any of those. So what they're going to do is they're going to send you a 1099 for the difference in the sales price and what you actually owed them. And then you have to, of course, give that to your accountant, and you have to deal with it however you deal with it. With the Mortgage Debt Relief Act, through the end of this year, even though they're sending that to you, it's not going to count towards income. So I'm not as worried about it, and I explain that to my clients. I'm not as worried about it this year, but it ends at the end of this year. And in fact, before the luncheon started, we were approached and asked, hey, what do you think they're going to do? Do you think they'll extend it? Because this is actually it's already been extended once. And my personal opinion is we're not going to know anything until at least the middle of November because of it being an election year. We have no idea what they're going to do because this isn't the only law that expires at the end of this year. There's also the estate tax that expires at the end of this year, and that also affects real estate. So I don't think we're going to know what they're going to do until we have a new Congress and a new president.
I think the question was, what do you discuss with them whether or not?
You know what I meant.
Do you discuss with them whether or not there's going to be a personal deficiency?
Oh, I'm sorry.
Yeah, I think that's what she's asking, and yes, I discuss it with them when I have conversations with them about things, and that is, this is our goal, and most of the first mortgage companies, at least, will extend that at this time unless they notify you in the process that we're not going to do this because of this person's other assets or their other financial considerations. And then you have to deal with it. But I go in with the assumption, and I tell people that's our goal, is that you will get a discharge of the entire debt, which is separate from whether or not you're going to have to deal with it on your income tax return. It's just that you're not going to get sued for the shortfall. Yeah. Well, yes, it's something you discuss with them, and sometimes you won't even know for sure until you get their last set of papers,
There's maybe a couple things. First of all, you'd expect a political junkie like me to have done this, I guess, but President Obama includes in his proposed budget money to continue the Mortgage Debt Relief Act. So he makes an assumption that that law will continue, but Tina's right that Congress has not yet extended it. So maybe that's optimism that it will, though. When I counsel sellers at that initial call, I like to know what their expectations are. My presumption is that they want to sell the home and not have any further obligation. But I address very upfront with them the fact that the bank may ask them to either contribute money at closing or sign a promissory note. I'm seeing less promissory notes than I did maybe a year ago, but I've still been seeing them. I think it's very important to understand what the seller's expectation is of that. And the reality is, if we've got sellers who are forced to, if you've got a job that's forcing you to move and you're current on your payments, but you can't sell your home for the debt you've got, it's very unlikely that the bank, on first glance, is just going to let you go from that debt. So I think you look at that scenario and say, look, it's realistic that we might not be able to get this done where you owe nothing from closing, but what are your expectations? Do you have funds available, or can you make funds available if it's required of you to contribute at closing? Not necessarily to make up the whole amount, but to contribute. In the same regard, are you willing to sign a promissory note? When the negotiating happens with the bank, I get very involved in that because, our offer to the bank is you accept the offer on the table and give us no deficiency. The bank comes back and says, we think the property is worth more than you do, and here's what we want. That's my opportunity to go to everybody and figure out how we get the deal done. Now, I'm very hesitant to go to a realtor and ask them to cut their commission because you're going to tell me you've worked harder than you've worked on any other file on this one, and I think you're probably right about it. At the end of the day, the bank's I think, are much more willing to pay full commission, 6% commissions on listings where there's 2 realtors. But oftentimes I can get the buyer to increase their offer slightly. Even an additional $500 or $1,000 goes a long way. Melinda, you said, you're dealing with one where there's a $10,000 gap.
Yeah.
My first approach would be to go to the buyer and say, hey buyer, are you willing to come up at all? Give me your highest and best offer. If we get $2,000 out of a buyer, that's $2,000. Then I look at all of our closing costs and figure out, is there something that can be cut? Is there something that the buyer's willing to pay for? Is there something in here that gives me a little more money to deal with? And then the last question is to our seller. Seller, here's the deal. We're $10,000 apart. The buyer came up 2. I found $500. Are you willing to contribute anything at closing and or sign a promissory note? If if they say, well, look, Dad said he'll loan me $3,000. Okay, now I've got, now I'm up to $5,500. Are you willing to pay $100 a month for a couple, 3 or 4 years? Well, yeah, I can afford that. Anything to get me out of that. Suddenly, I've presented almost $10,000 to the bank, even though my purchase price only went up $2,000. It's if your seller is willing to do it, it's hopefully a creative way to create an incentive to the bank to approve that deal.
What I find to be a real pain is when you get down to the very end and you come up with some nitpicky, well, we're not going to accept this. Well, it was on the last 7 HUDs we gave you, and now you're not going to allow it. And, oh, well, Chicago Title put it on the wrong line, so this won't be permitted, and then you have to go back to the title company. I use Chicago Title as an example, but any title company, and they might have to put it on a different line in order to approve it, because Lord knows the fees for such things as title work is a lot more reasonable here than it is in a big metropolitan area like Chicago. So why are they doing this stuff? I do not know. But I have come to believe that it would be wise as an attorney to get my client seller to put $300 or $400 in my trust account early on so that I have it available to pay some of this stuff at the closing rather than, and I'm not talking about a deal breaker thing, but I'm also talking about a thing where you shouldn't have to pay it and I shouldn't have to pay it. I mean, just because it's something that's come up at the last minute and the aggregate's $300 or $400. That's just been something, a recent transaction I had the person put $200 in and we spent 90 of it, okay? But, this kind of stuff happens, and for no more than what either you or I am getting out of the transaction in terms of your commission, my fee, I don't think we should have to bear it. Now, that's a different issue than what Jason's talking about, which is the more the deal breaker issue. Can you come up with some more money? But I don't feel comfortable going to any party, including the buyer, at the closing and say, kick in another $247 because these items that have been approved all along are now no longer approved. And nobody's got any money for it. That's just a practical issue.
I was saying, I've actually run into one where the lender wouldn't approve the P-tax. I know, right? And I explained to them that, well, we have to pay that, that's Illinois law. Well, then you need to provide me with that, and it can't be on your letterhead. And I'm like, okay, I'll give you a copy of the law. Well, not if it's too long. Okay. So sometimes it's silly stuff like that you can take care of after you get done rolling your eyes.
Yeah.
Stephen, I'm glad you brought up the HUD form because I've had, when sellers negotiate on their own behalf, I've had the bank ask me to complete a HUD form, and I feel really uncomfortable doing that. And I found that Chicago Title will do it for a nominal fee. And sometimes I could convince an attorney just to do a one-time shot at a reduced rate. But what is the realtor's risk if they were to go ahead and complete that form, the HUD document?
Being the preparer of the HUD?
The bank has asked me, multiple banks have asked me.
I'm not I'm not in a position to advise you, okay? But I would not think it would be something that I would want to do if I were in your shoes.
Yeah, but they act like it's just common practice.
Well, it may be because they're national. They're not looking at what goes on from state to state or locality to locality. And sometimes, you go to some states or localities and they have very little lawyer involvement in anything. And I don't know what their laws are. I don't know what they require. But I think sometimes you're dealing with somebody in some remote location that is thinking of anything but what your responsibilities are. And say, well, we got that elsewhere.
So understanding you can't advise us, but from your vantage point, if a realtor is filling out a preliminary HUD, does that not at least create a much, much greater risk that something's going to be done incorrectly and then expenses are going to be disallowed that would have been caught if that hadn't been done by the realtor who wasn't really supposed to be doing it in the first place?
Well, I like to have two sets of eyes on it. I like to have mine and the realtors on the HUD because of different perspectives, because sometimes I don't remember everything that needs to go on them. So I guess the answer is yes, it's more likely if only one set of eyes are on them, it's going to be having a mistake or a problem. And the other thing is, if you undershoot anything on your first estimates, try to go back and get the negotiator to approve something larger. I mean, it doesn't happen. So you don't, that's one of the problems I find too. It's very frustrating is they'll give you a date for a closing. No way they're going to approve it by that date. They want you to prorate the taxes. No way or is that proration going to be accurate because they're not going to get you an approval by then. And then you come back and you shoot them the proration that's 45 days later for the realistic closing date and, oh, well, that's too much. It's just not allowed. Yeah, I mean, you run into all kinds of stuff like that. And it's, I don't think it's that we're necessarily more skilled or talented than anybody else. It's like the more experience you get, you just, factor that in. It's like, well, here's another potential pitfall you just got to try to avoid. And I think after you do it a while, from the realtor side, I think those of you who've done several of them, I think you realize the same thing after you've done about the 6th or 8th one. You're more knowledgeable about what they're expecting, what they might approve or not approve than you were in the first couple of them. I don't know that answers your question, Matt, but
it was intended to be a leading question to get you to scare the crap out of the realtors.
Well, even setting aside even the legal liability of filling out a HUD. I mean, the reality is, if you fill out a HUD, and let's say you forget the $700 title insurance policy, and everything gets approved, and the title company or the seller's attorney or someone says, okay, now we're generating the numbers, and your approval doesn't include the title insurance, you are certain that everyone is going to ask you to contribute that $700 because they're going to say, well, you prepared the stupid thing 6 months ago.
That's the answer.
So,
which is why I like 2 sets of eyes on, because I don't want them to look at me and say, oh, you're charging $700 for the deal and you just overlooked $800, and so you're responsible for it.
Would the panel touch on, because you talk about first and second mortgages and mechanics liens, but I don't know if everybody knows about HELOCs, and also the fact that VA has to have 88.13% of the value on the home. Would the panel touch on that, on the HELOCs and the VA loans?
Take it away.
I'm not done with a HELOC.
well, I mean,
Well, I know, but I mean, I haven't done one on a short sale.
yeah, I mean, a HELOC, to me, a HELOC is it's a second mortgage for which we've got to find out, we need a payoff on it, and then we will.
Right, but some of the banks are not writing those off. They're expecting the homeowner to
Absolutely.
bring it to the table.
Yeah, I mean, so one of the trickiest parts of these is dealing with the second, whether it's a HELOC or whatever it is, the subordinate lien holders are always going to be a challenge. And, all I can say is you've got to make that analysis up front as to whether you have someone who will reasonably cooperate with getting, with negotiating or coming up with some solution that includes them releasing their lien. The ADE, the value of the VA loan, I presume you're saying there's some criteria out there for which they need to receive.
Right. So everybody's aware of the VA loans because they're real picky about it.
I would also stress again with the seconds, whether it's a HELOC or just a straight out second mortgage, that if the primary is a Freddie Mac or a Fannie Mae, they're not going to get anywhere near what they're owed. So it's helpful to know what kind of primary mortgage they have also.
I got a better suggestion. If there's a second mortgage involved, contact one of those two. It is really a pain to deal with. There is no doubt about it. And there's no way of predicting how they're going to do it, how they're going to handle it.
It's easier if it's the same bank usually. It's when there's three separate banks. Yeah, exactly.
It's easy if it's the bank. They do really well. They're quick.
Yes.
Who?
UC.
Oh.
Yeah. They're local.
Yeah.
Don't let them hear. Is there anyone from Busey here? They don't like to hear that.
Well, they're good to work with.
Yes, I agree.
Sure.
Yeah, okay. House has been on the market now, and we've been waiting 90 to 120 days to close. Buyer's been patient, but then buyer says, this is it. I want out. Okay, house comes back on the market. Is there any way to determine, since the bank has had all this time to determine whether they want to close on it, what the problem might have been? Is there some disclosure? Does the selling realtor privy to, like, okay, maybe they wanted more money, or, I mean, I'm in the dark about why it's taking so long, so am I going to be told so I can rectify that in the next go-around?
I'll let them answer because I think I know what you're talking about.
Only if we know, because I've actually encountered that. And yeah, it sat there and it sat there and it sat there, and it went through 4 negotiators, and I kept calling and calling and calling, and it was just never addressed. And so there wasn't really a problem. And so on the next one, we were actually able to get it sold. Sometimes they do let us know what the problem is, and then we can rectify it the next go around. But sometimes we're as in the dark as you are, and they just don't tell us.
Sometimes I think things change. It's like a moving target. And try to go figure them out. I don't mean that as a joke. I mean, really, it is really hard sometimes to figure out why something would have happened one time and it didn't another.
And you have to ask just the right question in just the right way to get the answer. Because you think it's a yes or no question, and to them it's not.
You may never get the answer.
Yeah.
We're on the front line. We go to our listing appointment, and we do our market analysis, and then they tell us at that point, well, we owe more than what that's worth. So you're sitting there with running through scripts and things of what you're supposed to say to them. The seller is saying, let's just give up now. Let's just say, what if we just stay here, we don't make payments, and we just wait for the bank to kick us out? I mean, what good advice do you have for us to say to them right at the front line?
I actually had a conversation with a client because they called me before they called the realtor, and they said, here's where we are. We're not upside down yet, but it's going to happen, and it's going to happen soon. So we're thinking we'll just let them foreclose on it, and we'll stay here until they kick us out. And I said, well, how's your credit now? Oh, we've got great scores. And I said, well, then why would you ruin it by letting the bank take it away? I said, you have 3 options, and each one makes your credit a little worse. And so I explained the short sale to them, hey, we can ask the lender if they'll take less money, and yes, it will ding your credit, but not nearly as bad. You will still be able to get a home to live in or a car to drive. You can ask the bank if they will do a deed in lieu of foreclosure, and in my experience, the deed in lieu of foreclosure is harder to get than the short sale. I said, but that'll ding your credit even worse, or you can sit there and wait for them to just foreclose on your house and ruin your credit, and then, you know, next year when you try to go buy a car or find a place to live, you're going to be crying because nobody wants to deal with you. So I would say, you know, explain to them that of the 3 choices, this is the best one because they have a team. They're not on their own. They have a team to work with them to try and clear it up. And so that, you know, you have a happy buyer and you have a seller that can actually go out and find another place to live without a huge amount of difficulty.
And remember, a foreclosure may not end it for them. You know, if they owe $150,000 and the bank gets $120,000 through a foreclosure action where they sell the home, they may still be liable for $30,000 after that foreclosure, for which they either need to pay or declare bankruptcy to rid themselves of. So.
What you tell them is they're in a unique set of circumstances. With this economy and this political climate, they are able to get a potential free pass on a debt that they can't pay, okay, and not really horribly affect their credit if they go through the short sale. And I don't know of any other time during my practice of law that anything like that's been available.
You know, one other component too is there has been government programs put in place, federal programs that historically have provided sellers a small amount of money at closing for relocation costs and otherwise. There's some new programs in place, and more times than not, people don't qualify for them. But I had a seller maybe a month or 2 ago who short sold a property and walked away from closing with $26,000. Yeah, I couldn't believe it.
It's part of
And
the
it's-
incentives.
yep,
They're government incentives.
So if you need motivation, tell them they may qualify. Now, I would not.
Let's not elevate their
yes.
expectations, though, because it doesn't happen that often.
Right.
Right.
So Jason, you said that they could file bankruptcy on the deficiency, but then what about the tax ramification? They can't file bankruptcy on owing the IRS, could they?
Right.
Well, and that's a key factor, and that is, this has happened in more than one instance, usually in the businessman's scenario, where somebody thought they were helping the bank by having their farm auction, they sold off all their livestock and equipment, paid down their bill, and now that generated a bunch of capital gains or recovered depreciation, ordinary income. Now they owe the government for that. That cannot be discharged. But if they had filed the bankruptcy before jettisoning all those items, okay, they could have discharged the debt in the bankruptcy and not have triggered a tax liability pre-bankruptcy. Okay? It's a timing thing there. It's really important. That is clearly form over substance, because the substance is that the guy's out of business, okay? The reality is that if he does that by selling in advance and creating a taxable income, that income can't be discharged in the bankruptcy. Whereas if he had filed the bankruptcy and gave it back to him, to the creditor, then he would not have had a taxable event.
Any other questions? Well, thank you for coming. Thank you for